Let's turn our attention to the courts. A senior advocate of Nigeria, SAN, and a partner at Afe Babalola law firm, Olu Daramola, has filed a 500 million naira suit at the Ojodu Abiodun Division of Ogun State High Court against Dele Farotimi for alleged defamation in his new book titled Nigeria and Its Criminal Justice System. The suit was filed barely a month after the one filed by Afe Babalola, SAN, over similar and alleged defamatory words in the book. The right, dated December 13, 2024, was taken on behalf of the applicant by Ihanichuku Siwa on behalf of Daramola. The claimant is seeking a declaration that the book authored by the defendant and in circulation within and outside the country and within the jurisdiction of the court contains some defamatory words on page 64. Let's get some perspective from the legal standpoint on these cases. We're joined by legal practitioner Tunji Abdulhameed. Tunji, always a pleasure to have you on the news. So barely a month after the one filed by SAN Babalola, we now have this one. No date has yet been fixed for hearing though, but I'd like you to explain for us, how does this really work? Will both cases run concurrently? And can more persons who feel defamed join the suit?
Yeah, thank you for having me, Felicity. I think this one filed by Chief Afe Babalola and the other two filed by lawyers from the two SANs, the one from Ibadan, the one other state, I can't remember the names now, and the one just filed by Mr. Olu Daramola SAN are separate suits, and that they can be determined differently. In fact, if more people feel that they've been defamed, they can also file their own. They don't have to join the one filed by these people. Since these are separate claims, and they have the right to file it in a different court.
All right, we know that Daramola, like Babalola, is seeking a court order to compel the defendant to publish an unreserved apology in widely circulated a national newspaper to retract some of those excerpts in the book. Is there a similar precedent that might impact judgment in this matter?
Yeah, I am aware of another court already regarding the fact that all the books already in circulation should be withdrawn. I think I have my sufficient regarding that because it's a principle of law that order will not be binding on anybody. In fact, if I have the book, nobody can come and say you are infringing on court order because I wasn't the party to the suit. I am not bound by the order of the court. The order should be directed at Dele Farotimi to direct his producers not to sell the book again. Not for me. If I have the book in my custody, I can't be charged for content. There's no way I can be charged for content because I am not a party to the suit, and I cannot be bound by the order of the court. So the order regarding no one is permitted to sell the book, no one is permitted to hold the book or whatever, I think it's infringed. As far as I'm concerned, with due respect to the court, because it's a well-known principle of law that when you are not a party to a suit, you cannot be bound by the order of the court, and you cannot benefit from that order of the court if you are not a party in that suit. So that order only binds people who are party to the suit. And who is the party here? Only Dele Farotimi is a party to the suit. Even those who are the publishers, they can challenge it. They cannot be bound by that order because they are not part of the case in court. So I see that order as a mere effort in futility with due respect to the court. They have the right to do that. To direct Dele Farotimi to ask his publishers or other people not to sell the book again. Not for them to direct those people directly to say, look, stop selling, stop doing this, stop doing that. I see that order as not properly given.
All right, I actually was going to ask you to address that, really, the feasibility of it to retract all those books. But now I would want you to speak on the request for a widely published apology, against about the defamatory words in the book. I'm trying to get to your perspective on if there is a precedence where an apology was widely circulated in similar circumstances, and how might that, if it is available, impact judgment?
Yeah, there are so many precedents because in defamatory suits, one of the reliefs are usually either monetary demands or apologies. So if you are asking for apology and it's granted, that means you'll be asked to do it in a particular form, and then you have to do it that way. So it's not abnormal; it's normal thing for you to do. In fact, sometimes when you render that apology, even before the other party may not even go to court to challenge you, he may even waive his right to claim any damages against you. It's normal in a defamatory suit, and it's common for almost all defamatory suits for them to ask for apology. That will only be granted when it has been established that you have truly defamed that person, or when you on your own believe that, or you want to say, look, I have agreed that my comment or my word or statement or whatever I have done amounts to defamatory statements. Then you can also render apology to close the case if the other party agrees without monetary compensation.
I guess I'll hold the rest of my question for when the court rules. For now, thank you very much, Tunji, for speaking with us.
Thank you for having me. It's my pleasure to be with you. Thank you.